Welcome to This Explainer. Okay, today we are tackling something that is honestly a massive storm brewing right under the surface of the corporate world. We're looking at a totally unrecognized legal collision course between two giant frameworks of law. And if you're in an organization, whether that's public or private, this is something you urgently need to understand. We are diving into the hidden and frankly quite dangerous clash between workplace safety and data privacy.
Okay, let's dive into this. What actually happens when fundamental workplace protection collides head-on with data privacy? Right now, the legal landscape is completely dominated by a different privacy conflict. The Supreme Court is already actively discussing the friction between the new data privacy law and the Right to Information Act. But while everyone is focusing all their attention over there, the entire industry is missing a much, much bigger HR blind spot. Think about it. What happens when the protections guaranteed to a victim at work directly clash with the newly minted data rights of the person they are accusing?
Section 1. A hidden legal collision.
So while the legal world is distracted by those debates around the Right to Information Act, the corporate sector is completely missing this unrecognized industry blind spot. It's the clash between data privacy and the POSH Act. And ignoring this specific intersection, well, it's not just some minor academic oversight. It is literally a ticking time bomb for human resources and legal departments everywhere. Both public and private sector organizations are absolutely bound by these two laws. Failing to see how they interact, or rather how they actively contradict each other, is going to be a massive legal and financial liability.
Section 2. The POSH Act obligations.
To really get why this collision is so dangerous, we first need to quickly map out the POSH Act. This is the foundational workplace safety law set up back in 2013 to protect women at work. Now, this framework throws some very specific, really stringent obligations onto organizations. 9 core mandates to be exact. First off, you have to constitute an internal committee to receive complaints, and that has to include a senior woman employee, 2 other employees, and 1 external member. You also have to maintain meticulous records, file annual reports, and of course, impose penalties when sexual harassment is proven. But perhaps most critically of all, organizations are legally bound to provide absolute support and protection to the complainant. So the crucial point here, and I cannot stress this enough, is that confidentiality is a strict legal mandate under the POSH Act. It is not just some nice-to-have HR guideline. Protecting the identity and the incredibly sensitive details of the complaint is the fundamental bedrock of the whole system. It's what allows victims to feel safe enough to actually come forward in the first place. Every single record kept, every internal committee meeting held, completely relies on this absolute veil of confidentiality. Section 3. Enter the DPDPA. Right, so this is where we introduce a highly disruptive new variable into our carefully balanced workplace safety equation. Enter the Digital Personal Data Protection Act of 2023, or the DPDPA. This is India's massive new data privacy law. Now, on the surface, this is a huge win for personal digital rights, for sure. It gives individuals very specific, powerful rights regarding how their personal data is processed, stored, and managed by a company. But think about this in the context of a POSH investigation. The individual whose data is being processed often includes the respondent, the person actually accused of the harassment. So this new law inadvertently arms the accused with powerful data rights that the original architects of the POSH Act simply never anticipated. Section 4. Where the laws clash. Now, what's really interesting here is exactly how this theoretical friction turns into a total administrative nightmare for companies. There are 4 specific areas where the rights of the accused directly contradict the protections of the complainant. On the POSH side of reality, you have confidential complaints and secret early investigations. That's how it has to work. But over on the DPDPA side, the respondent now has a legal right to demand disclosure of how their personal data is being processed. It gets crazier. The respondent can actually request the deletion or correction of their data. Just imagine a scenario where an accused employee demands you delete their data regarding a highly sensitive POSH complaint, a complaint they might not even formally know exists yet. Plus, the DPDPA mandates a grievance redressal system for the respondent regarding their data and literally extends these data rights to their nominees. The structural contradictions are just glaring. I actually want to pause right here for a second just to let the sheer gravity of this legal paradox sink in. If a company strictly follows the POSH Act to protect a victim, they might illegally deny an accused person their data rights under the DPDPA. But if they honor the accused's data rights under the DPDPA, they completely shatter the victim's confidentiality under POSH. Compliance with one could literally mean violating the other. Section 5. Complicating cyber laws. And this brilliantly illustrates how our little two-way collision is actually more of a multi-car pile-up once you factor in the digital footprint. Because let's face it, modern workplace harassment is rarely just verbal anymore, is it? We also have to consider the Information Technology Act of 2000, specifically regarding obscenity in electronic documents. We've got pieces of India's new criminal code, the BNS, dealing with cyberstalking. And then there's the BSA, the new Evidence Act, which lays out rules for certifying electronic evidence. All of these digital elements are deeply, deeply intertwined with modern POSH complaints. They create vast amounts of digital evidence, which is, of course, data. And that just further tangles up the rights of the POSH complainant with the data privacy rights of the respondent. It's a legal web.
Section 6, HR versus the DPO. Let's take all of this legal jargon and bring it down to reality to see what this actually means inside a corporate boardroom. Inside your organization, this legal clash is going to play out as a direct operational war between two essential roles. In one corner, you have the HR manager. Their core mandate is POSH compliance, ensuring workplace safety and protecting that victim's confidentiality at all costs. In the other corner, you have the data protection officer, or DPO. Their mandate is strict DPDPA compliance, making absolutely sure that every single employee, including the accused, gets their data rights honored. Without a formal legal resolution from the top, these two vital roles are basically forced into total opposition. This means there is an absolute urgent need for corporate alignment here. The industry has got to look this conflict in the eye and push for resolutions. A functioning organization simply cannot operate in a constant state of anxiety where POSH compliance poses a direct legal risk for DPDPA compliance and vice versa. The responsibilities of the HR manager and the DPO need to be sorted out and harmonized, ideally before the inevitable lawsuits begin. Which leaves us with the ultimate million-dollar question. It's a question that every single business leader, HR professional, and legal counsel needs to be asking themselves right now. How can your organization protect a victim's confidentiality when the accused has a literal legal right to their own data? It's an incredibly complex puzzle, but understanding the pieces on the board is the absolutely crucial first step to solving it. Thank you so much for joining me for this explainer, and I highly encourage you to take this question back and discuss it with your own teams today.